Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altition, Director of Client Partnerships here at Land & Home Family Law. And today I'm here with Lisa Parsons, a paralegal here at Land & Home Family Law to talk about the discovery process in divorce. How you doing, Lisa?
I'm doing good, Steve. How are you?
I'm doing well. So, Lisa, there are a lot of folks out there who really aren't sure what a paralegal is. And I can guarantee it's not a legal person jumping out of a plane. It is a real thing. And so can you talk to us a little bit before we get into discovery about what a paralegal is, what your role is, and how you interact with, the attorneys and the clients?
So I think the best way to think of a paralegal is essentially like they're a mini lawyer. Paralegals do just about everything behind the scenes. We aren't going to appear in court and argue your case before a judge, but we work with your attorney to draft documents, to gather documents and discovery, to do research. We're essentially a liaison between the attorney and the client. And so often we'll work really closely with clients and maybe have 2 to 3 times more contact with them on a regular basis as opposed to the attorney. This is certainly a financial benefit to clients, given that paralegal rates are substantially less than attorneys. But a paralegal is a fantastic resource for clients to use, and can essentially help with just about everything except giving legal advice. And we won't go to court and argue your case before a judge.
Well, it sounds like a really fantastic and an important skill set all of its own.
Definitely.
So let's move on now into what discovery is. We talked about this before. It's something that everyone hears about, everyone's heard of in about court cases. But what is it? What is discovery?
So discovery is essentially an information and documentation gathering process involved in all types of cases. In divorces particularly, we do have required disclosures or certain documents that you need to provide to the other party. But we use it as a roadmap to determine the complexity of a case or what preparations need to be made in anticipation of settlement, mediation, or trial. It gives us a lot of information, essentially what we're looking at in a case. We will gather records about debts and assets, and work closely with the client to identify everything that's involved in their marriage, as far as property and debts go.
So is discovery happen in every case? Is it mandatory to be in every case?
There is a mandatory requirement in all divorce cases. There are exceptions to the rule, and in certain circumstances, we might not do it. But from my experience, discovery is necessary in about 95 to 98% of cases. And it's actually to a client's benefit to do that, so that all assets and liabilities are identified. I've certainly had many situations where clients weren't aware of bank accounts or stock accounts or even a safety deposit box of another party.
So if someone says to you, I'm just not going to do discovery, I don't care if they ask, is that a viable option?
Many have tried. The truth is, when that happens, there are steps that in the legal profession we're able to take to essentially force them to disclose. If they refuse to comply with a formal request, you would submit something to the court asking a judge to compel or force them to provide that requested information or documentation. If they still refuse to provide it, one, it certainly helps your case to get your attorney fees covered, by that party. But there are also other, legal documentation that we can prepare and serve, such as on financial institutions, to go around that individual and still obtain records about their accounts, their retirement, their employment benefits.
Wow. Yeah, I guess bottom line is, you don't get to hide your assets.
No, unfortunately, when people try, it does end up being a costly endeavor. It's unfortunate when people feel that they don't need to disclose or they shouldn't have to because it's a hassle. And granted, it is a lot of work, but it will be more expensive in the end, and reduce what the parties have to divide because they're paying attorney fees, whether it's our client paying us to go after their records or them, being ordered to reimburse the other party for their attorney fees because they failed to do their job.
Yeah, and it seems like if your client wants to settle, they don't want to go to court. They want to get the things settled. They want to, for a variety of reasons, including, it's less expensive not to go to court. You need to have that discovery because no one's going to settle if they don't know what the other side has. Exactly.
And in those cases, unfortunately, after divorce, sometimes things are discovered. And when you found out that they had, $50,000 bank account they didn't disclose, that can be grounds to essentially overturn the original divorce judgment and have to start over because they failed to provide that information that was pertinent to their divorce case.
So you mentioned a little bit about the different ways there are discovery. One is you can ask for documents. You can ask for them to give you documents. And that if they don't, you can subpoena those documents. Are there other ways you can get discovery out of people? I mean, are there other people you can ask? Are you just relying on the good word of the other party?
No, absolutely not. We are able to discover information and documentation in other ways, one of which would be deposition. We can take the other party's deposition and ask them questions while they're under oath, and it's on the record. Those depositions are typically recorded by a qualified court reporter and do come into evidence in hearings and trials if it gets to that point in the case. We're also able to depose third parties. So if the other party doesn't disclose their employment benefits and their earnings, we can depose their employer and obtain that information in other ways. We also have an option of doing a request for admissions, which is essentially a signed sworn statement where you answer questions and provide information when you're essentially under oath.
Wow, it sounds to me like discovery not only is very important, but is a large chunk of a divorce case.
Absolutely, Steve. I often tell my clients that it's going to be one of the more expensive portions of their case, but it is so valuable and important. And when you do the work on the front end and you gather and provide the documents that are requested of you, it saves a lot of time later on in the case.
And it sounds like using you saves a lot of money because a lot of that stuff, do you want to pay your attorney, attorney fees to go get documents, to gather them, to put them together in a form that works when that's what your skill is?
That's absolutely right. It's far more cost effective to have a paralegal review and organize them and pull out the pertinent details that the attorney's going to want or need to know, or to flag things. If you see a $10,000 withdrawal from a joint bank account, as a paralegal, we might flag that to the attorney and say, hey, this $10,000 was withdrawn, and I don't see that it was deposited into another account. It basically reduces the time that the attorney needs to spend going through those records, because a paralegal's already gone through and organized and prepared them in a way that will be useful for that attorney.
You know, you hear from a lot of people, you know, that, well, my attorney just pushed me onto the paralegal. Like that's some bad thing. I mean, someone shouldn't say, oh, I'm talking to the paralegal. They should say, wow, I'm talking to the paralegal, because it helps the case. So let's talk a little bit then about the case, the process of discovery. When do you get started on this thing? I mean, you know, obviously, I guess you got to wait until a client signs up with the firm, but I mean, how soon does the process have to get started?
Almost immediately. As soon as I have information that's necessary to draft their initiating documents, you know, we like to tell clients, here are the types of things that we need in a case such as yours. It's a good idea to start gathering them now, particularly because there are rules in place that say you need to produce records within 30 days of being served or serving your petition. So if a client can get working on that even before we file their initiating documents, it's going to save time down the line, and a client can work with the paralegal to determine what's missing or what additional information is needed after having provided some of those preliminary documents.
So what, just, I know there's probably a ton of different things that need to, you get, and it probably varies from case to case, but can you give us a kind of a flavor of what sort of documents people should be aware of that they're going to try to have to find and get to us?
Typically, tax returns are almost always necessary, and we request 1 to 3 years. That includes your W-2 statements, typically earning statements for the current year or a full year of earning statements. We also ask for bank statements, typically about a year's worth of bank statements, a credit report, Social Security statement that shows your lifetime earnings record. We'd ask for at least a year of credit card records, a real property mortgage statement, or a deed to your house, the title to your car. I often ask clients to pull Kelley Blue Book valuations on their vehicles, because that's a helpful tool for us in our process. So it can be quite substantial.
In terms of, so I say to you, if I'm a client, I go, why do I have to do this? Why do I have to do this? Why do I have to get that? It sounds like, even though there's like you said, the mandatory production of documents, there's a lot of other things that happen in a divorce case that are going to need some of this stuff. I mean, even if you're not going to go to a trial, maybe you're going to go to what, mediation, or I mean, do you need it like to get temporary orders or support? Is that all involved in this?
Absolutely. One of the most frequent things that we do is review earning statements, typically asking for the first earning statement for either the calendar or fiscal year. You might get paid on January 1st, but the pay period beginning date is December 22nd. So that information is really important. In addition, we would ask for like a current earning statement to calculate your income in several ways. Salaried employees are a little bit easier, but people who earn an hourly wage, we would run their income several ways. We would do a year-to-date breakdown. We might look at last year's W-2. And so all of those details are very important, especially when support's involved.
And you're doing a lot of this financial gathering and analysis as part of your job, as part of being a paralegal.
Absolutely. So I would take that information and essentially prepare a form that says, here's their income, here's the 3 ways that it's been calculated, what looks most accurate. And the attorney is going to review that and then determine what is most appropriate to use for our purposes. That will then be, a determining factor for child support or for spousal support. And so I'm presenting that information to the attorney after I've worked with the client to gather and review those records.
And you're not just beating up on your client. This is also something that the other side is having to gather, and you are expecting it. And if they don't give it to you, you're gonna go after them. You're gonna demand it. I mean, this is not a one-sided deal.
Absolutely. We can't control what other attorneys do and what their practices are, but what we want to do is make sure that our clients are in compliance, that they're doing the job that they need to do, and that we're providing records and information on time. We certainly aren't going to hand over all of your records without a conversation and reviewing them. There are certain times when records aren't necessary for production to the other side, but they are valuable for our purposes, such as Kelley Blue Book valuation of a vehicle. We would want to know that information when we're identifying assets and liabilities of the marriage and assigning values to those assets. But we may not disclose that to the other side until we're at a later phase, such as mediation or trial.
So you're not doing work for the other side. You're not doing work for them. You're doing work for you, for your client.
Exactly. And to prepare my attorney to the best of their ability to represent that client and have all of the information that they need to do that.
It just makes complete sense. So what if someone doesn't have some of the stuff you want? And obviously, this is a two-edged sword, because you're going to send a request for production, but they're going to send it to you, and you're going to go to your client and say, these are the things we need to give them. And what if they say, well, I don't have it. I'm not even sure how to get it. I know there's a term called possession and control. How does that all work?
So essentially, the way I like to look at it is possession is something that you actually have at your disposal. It's at your home. It's something that you can access, through your computer, something you can easily get because it's already in your possession. Control is more something like bank statements and credit card statements. You might not readily have a year's worth of statements at your disposal in your house, at your home, on your computer, but you have the ability to go to your bank or contact your bank or log in online even and request historical statements. And so when we're saying if this is something in your control, it means you have the ability to go and obtain it. I think a distinguishing factor may be something like if you filed tax returns jointly and you use TurboTax, but you don't have any of the login information because you weren't the person who created that account. That's not necessarily going to be in your control anymore. That would be in the other party's control. But if you use TurboTax together, you have access to TurboTax and that login information, you would have the ability or within your control to go and download your tax returns and provide those to your attorney.
What about information that, and I think you've kind of hit on this, that is not necessarily required, or that you may need going on? Do you try to get all the information as early as you can, or do you wait at times if it makes sense to get information later, depending on what's happening? Is that sort of a decision that's made as you gather information?
Absolutely. Often getting the preliminary information, like I mentioned at the beginning, it creates a roadmap. It helps us determine what is needed and when it will be needed. Discovery is an ongoing process that will be a portion of their case from start to finish. If it's going to mediation or trial, we're going to need updated statements, updated pay records. Sometimes we tell clients, just send them as soon as you get them. It's better to just already provide it to your attorney. That way, when that need arises for trial or mediation or hearings, we already have the information at our disposal. But we work closely with clients to make those decisions and determine what is the most cost-effective way to provide the information that we will ultimately need for their case.
And in kind of a dumb question, our clients don't have to guess about what they need to provide you. You're pretty specific on the stuff you send them. Can you kind of give us an example, maybe, of what you actually send out to them, so that it's not like, oh God, do I have to guess what does financial information mean?
Right. So at the beginning of a case, I would often send clients a checklist. And the checklist actually says, provide your last 3 tax returns, provide these specific statements for this period, provide, your life insurance declarations, something of that sort. So I would actually give a client a checklist. When we get a request for production of documents, similar information is provided. And oftentimes we're giving clients instructions on how to even pull that information. If you're asked for credit reports, certainly there are several ways to pull credit reports, but we will actually provide step-by-step instructions. Here's how to create an account at creditkarma.com. Here's where you go and what you click to, obtain the report that we're looking for. Or similar with the Social Security statement, we actually provide the website and information on how to go about getting that information. And paralegals work closely with clients to pull those records oftentimes.
So you sort of work hand in hand. They're not just out there in the technical forest of darkness trying to get this stuff themselves.
Exactly. The priority is to have that open line of communication so that a client can come back to us after a week of looking at this checklist and say, man, I'm overwhelmed. I got these things, but I'm having trouble here. And paralegal can give further direction, can give assistance, show them easier ways to obtain it, or make a determination whether it's even necessary to provide.
And I'm also pretty sure that there are things that you have to produce or your client has to fill out and sign, depending on whether there's child support or there's maybe spouse support or all these kinds of things that have to be filled out and have to be filled out correctly, or else you can get, not only maybe don't get a good result, but can get in trouble with the court.
That's absolutely right. In cases where support is an issue, we need to complete a form that's called a uniform support declaration. Basically, it's a form that focuses on your income and expenses. And we need to identify what your monthly expenses are, as well as your gross income.
The kind of following on that, there are reasons, I'm assuming, that aren't just about the stuff you own that you may need discovery on, because you also work, I'm asking as a paralegal, especially with the attorney and the client, on some other issues that aren't necessarily just financial. Is that correct? And I'm thinking in terms, I guess here what I'm thinking of is what about things like visitation or those kinds of things? Is there discovery sometimes used in trying to determine, which party is more involved with their kids or school records or any of that kind of stuff?
Absolutely. It's certainly a bit case by case, but when children are involved, we often like to tell them early on You should start keeping a journal and make these types of notations. And here's the things that we will ultimately need to know when we go before the court to argue that you should have custody of your children. And so oftentimes we are looking for records that have to do with their routine, their schedule, their attendance for school, or their grades. And so there's definitely information that is asked for or necessary for issues such as parenting time and custody.
So let's say you're the other side, makes a demand for something. Give me this, either a document or information or whatever. Are you necessarily obligated, or is your client necessarily obligated to provide that information? What if it's, are there kinds of information that you can object to having to turn over?
Absolutely. The rules don't require that you create something that doesn't already exist. An attorney might tell you, we want you to start creating this log, but we're still able to object or indicate that it's work product, or it falls under an attorney-client privilege. We work really closely with clients to determine when and if things shouldn't be produced, or whether to even provide information. I've seen requests where they're asking for name and contact information of a CPA. You can provide that. But the rules don't necessarily require us to provide that information or list it within a formal response.
Are there protected documents? And I go to out something like a doctor or a pastor or a medical provider. Are there things that you may end up gathering or not, but ultimately don't need to be turned over to the other side?
Definitely. I think, on a case-by-case basis, we determine whether those sorts of records are needed, whether maybe a medical condition affects ability to work, or if an injury is preventing them from returning to work. We might obtain those records, but they are protected. And so it may be necessary to prepare and file a document that essentially prevents that information from being disclosed or used in certain ways, where if we are required to provide it to the other side, they can have that information, but there are limitations on what can be done with it. That way, individuals' confidential records or medical history remains confidential.
And I'm assuming that in terms of what you turn over to the other side, that if they're demanding it, it has to at least be relevant or lead to something that's relevant. I'm assuming they can't ask, and you provide every time you logged into Twitter in the last 30 years.
They can absolutely ask for that, but there are objections that can be raised that essentially say this is outside the scope of discoverable issues for this case, or essentially telling them, you need to explain the basis. Why is this important? Why do you need this to prove your case before we necessarily have to provide? We like to tell clients to gather and provide everything that's asked for and provide, response details for each item requested, but that doesn't mean that we're going to provide all of those records or give those answers to the other side. It's often for internal purposes so that we can prepare a formal response and protect our clients' interests and rights.
I imagine you have many phone calls with your clients about these exact kind of situations.
Absolutely. Doing discovery is not wham bam thank you ma'am situation. It's something that, you know, it's ongoing. There needs to be open lines of communication. There's a lot of back and forth determining whether something exists, whether there's more to it when something was opened. And so, you know, you really do work a lot with client and paralegal determining what there is and how to respond to these things.
You and your clients, at least for a period of time in that case, can become very close.
That's absolutely true. I don't think there's any way not to. It's such a difficult time in your life to be going through dissolution of marriage, and it's heartbreaking in itself. And then to be given a list of 25 or 30 or, you know, even 10 things that your attorney is saying you need to provide, it's overwhelming. But the paralegal's here to help, to guide, to assist, and really work with you on that so that you don't feel overwhelmed and like you can't do what's being asked of you.
And I'm assuming that it's not unusual to see where people can use this process as a weapon, and, you know, really use it as a emotional weapon. And, you know, they want to embarrass, they want to annoy, they want to harass their soon to be ex. You have to see that a lot, from both sides, I imagine. I mean, you know, yeah, it's pretty easy. The other side, you can tell them whatever, but, you know, I mean, you have to have a conversation, I guess, with your client if they want to do that.
Absolutely. And discussing the pros and cons of it, or the financial implication of doing some of those things. It's certainly an emotionally charged situation, but our goal is to guide you through this process. A divorce isn't a situation where you just hire an attorney and they're going to do everything for you and you get a check out. You need to actively be involved in the case and provide information, records, answer questions. As a paralegal, oftentimes I will draft documents from the client's perspective. So I need to get inside the client's mind. What did they experience? What did they go through? And be able to articulate that into, you know, a form or response that's necessary for the case.
And that kind of leads to my last kind of topic on this. This isn't just about you interacting with the client, getting the information, doing all of this work, analyzing, putting it together, putting it in different ways. There's an end result. I mean, there's a reason for doing this. And it, you know, I guess that comes out on the other end where you're interacting with the attorney. And so the attorney, how does that work, just in a little kind of short form, in terms of, like, you take all this information, now you sit down with the attorney, and what kind of a conversation can go on at that end?
You know, typically what I would do is prepare a spreadsheet that's identified all of the assets and the liabilities and assigned values to those items. I would also prepare you know, a calculation sheet for each party's income. You know, there would be one for our client, one for the opposing party, and then another one that has to do with support, whether it's spousal support or child support. And this information is given to the attorney, and we sit down, review it, and determine, where's the case going to go now? Is it possible to settle? Are these issues things that can be easily resolved? Or do we need to prepare for trial? And what would we need to prove our case or our position on certain things?
And you have taken a raft of information. I mean, you know, how many pages? Just kind of just a real ballpark. I mean, it seems like we're talking about a lot of pages of information you're going through, and you're ending up giving the attorney this focused analyzed reports that have taken 1,000 pages and then turn it into the 20 essential pages kind of a thing of how to go forward. Am I overstating that, or it sounds like that's what kind of happened?
No, you're right on. I have cases where an electronic discovery binder might have over 2,000 pages, and I've condensed the pertinent details from those records to a 2-page summary that has all of the notes and information that we would need to then create an asset and liability spreadsheet, which is often 2 to 3 pages. Wow. And those income calculations and support calculations are 2 to 3 pages. So we're talking about taking over 2,000 pages of records and condensing them, to under 10.
This has been really fascinating. It really has. And I think anyone listening can kind of not just understand, but appreciate the value of what you do, not only to get the best result, but, save them a boatload of money. I can imagine that, an attorney fee going out where they did all that, which, and you're frankly, that's what you're trained to do. It seems like, paralegals really are clients' best friend, kind of a thing. So I just thought it was great information all the way around. And thank you, Lisa, for joining us today. You provided just a tremendous amount of insight, and thank you very much for doing that.
Wonderful chatting about it.
Yeah, it's fun.
This is obviously a really big subject. There's a lot that goes into it. But it's a really vital part of all divorce cases. And, a paralegal is here as a resource, as a tool, as, a companion through this process to navigate and explain things in a way that makes sense, as opposed to just an attorney explaining to you, here's what the law says, and here's what it does, and this is what's going to happen.
Yeah. And I relate to this, I like to cook, and I relate to this like, when I want to make a dinner and I'm all excited and I'm going to make the greatest dinner tonight, and then I find I don't have, the garlic, or I don't have the balsamic vinegar, or I'm missing an ingredient, and I'm going, well, why don't I have that in front of me? Just because I want to make it. You provide the balsamic vinegar. And not only that, you provide how it's best used, and so I can make a good meal. I mean, it's kind of a funny analogy, but it's really the distillation of you're going to do better. Your client's going to get a better result when everything is available. So thank you so much for helping show that. Also, I do want to thank everyone who tuned in today on our Facebook Live broadcast. And if anyone has questions on today's topic, please feel free to post it here. You can also shoot me an email at steve@landerhomelaw.com. And until next time, everyone stay safe, have a great day, and welcome to the sunshine. I think we got spring coming finally.